Is there any board comment? Yes.
Mike, just so I'm understanding the underlying bill correctly, it's, so if a consumer has or installs an air conditioning system, they have to register it with the state.
I think what it is right now they're going to create a tracking system for the purchases of HVAC systems, and whether when those systems are installed, whether a permit was pulled, and the sale and purchase of these systems, and who purchased them by license number. My understanding is that this is already required, but this would create a tracking system of this. And then the second would be compliance with Title 24 installation requirements, including the acceptance test requirements. So it's who bought it, whether it was installed correctly with the HVAC requirements in Title 24, and then make that information available to agencies that are identified, and one of which would be CSLB. So my understanding is CSLB would be able to search this registry to search for permit and job installs, and for instance, if it gets a complaint, it could check to see if a permit was pulled for that HVAC system and that kind of thing. That's my understanding. I'm not sure, and I don't believe the consumer is going to be required. I think that was your question. I don't know that yeah, I think it relates to the market, the sale and install of these systems. And then the sales side would be the registry and identify installs, track sales, and by the license number of the contractor who installed them. And then the second part of this registry would be the installation part, which is acceptance test installation and permit requirements.
Okay. Any other questions from board members?
Through the chair. Question, Mike, on that, for if there's a permit just for a replacement or a change out, it sounds like it would be for something new being installed for Title 24. My question is if it's something that's just being replaced, changed out, taking one furnace out, putting in a new one, or one unit out, and placing the unit where there wouldn't be any Title 24 testing because it's obviously it's an upgrade, how would you collect that data? Because that wouldn't be there. There'd be just a regular permit for a replacement, showing a replacement, but nothing for a testing of any sort.
I am not sure if that would be tracked by this system. Right now, it's something that the CEC is being asked to research how to do and create this tracking system. I don't know. So you're asking if there's no permit required for the.
But there would be a permit required for the replacement of the unit itself, but the ductwork and the actual testing of that ductwork, there wouldn't necessarily be a requirement for Title 24 for that because it's all existing. There is no change out of that as well. So assuming that everything is working correctly, the only thing you're changing out is the actual unit itself. So furnace for a furnace, a unit for unit, there's no ductwork, nothing's going to be, there's no testing, it's no more than 10 feet, there's nothing being done. And I just don't know how that would be done. Maybe I'm trying to say if there's somebody that's involved in that, I would love to be a part of it. If they'd like to ask me any questions or I could ask them, that'd be
absolutely. Great. I will make that connection. And one of the things, if the board does vote in support of the bill, and the reason staff recommended the support recommendation is because we have a sponsored bill, AB 1747, that is intended to ensure contractors comply with HVAC permit installation requirements, and this bill sort of aligned with that policy objective. But as to the nuts and bolts of how this would roll out, I will absolutely, regardless of any motion here today, I will reach out to the author's office and make that connection because I think that's important information to
That'd be great.
To have.
Thank you.
Any other comments or questions from the board? Any comments or questions from the public? Mariah, will you please call the roll?
Susan Granzella?
Aye.
Frank Altamura?
No.
Rodney Cobos, approved absence. David De La Torre, approved absence. Miguel Galarza?
Aye.
Alan Guy?
Aye.
Diana Love?
Aye.
Michael Mark?
Aye.
Steve Pinelli.
Yes.
Jim Ruane.
Aye.
Johnny Simpson.
Aye.
Mary Tykert, approved absence. Motion passes.
Thank you, Mariah. Our next item is on page 166, SB 1443. This bill changes the statutory sunset date of the CSLB from January 1st, 2024 to January 1st, 2025. Mike, an update, please?
Yes, so in full disclosure, this bill should actually have been in the previous section because the board has already reviewed it and nothing is being requested, but it does, as we discussed in March, it does relate to the sunset date of the Contractor State License Board being extended 1 year because of COVID delays created for all the sunsets for all the agencies. Thanks.
All right, thank you. The staff has not made any recommendation, as Mike said, on this bill, which amounts to a watch or staying neutral. As a result, this is an update only, and no action is required of the board unless a board member makes a motion. Anything from board members? Anything from the public? Okay, our next item is on page 167, SB 1495. As of today, this bill does not affect CSLB. However, the board packet explains that staff worked with the board chair and I to suggest technical amendments to this bill regarding the CSLB solar restitution program. Mike, can you provide some more information about this also?
Yes, this is one more that we worked with the board chair and the legislative division chair to make a technical change to the solar restitution program at CSLB. It involves the disclosure against a license that is subject to a restitution fund payout and whether that license has gone through CSLB's disciplinary process or not. So it was going to be cleanup language. We requested to clarify that portion of this restitution fund. The language is not in the bill, and we did request it, but it has not occurred yet. So there's no staff recommendation today. It's just an update that this occurred. And if there's any questions, I'm certainly available to answer them.
All right, as Mike explained, staff has not made a recommendation on this bill, which amounts to watch or staying neutral. As a result, this is an update only and no action is required of the board unless a board member makes a motion. Any board member comment? Yes.
Mike, I wonder if you just expand upon, and I think you touched on it in the description, but, you know, if we're waiting to disclose this until it's revoked or pending revocation, then what's the point?
So when this program was created, it was assumed that a lot of the contractors that were identified, and there was a number of contractors that were identified in this Central Valley as selling these PACE loans and having installations done on these homes. And CSLB wound up revoking a lot of those licenses. A lot of them were unlicensed. And this fund was created to kind of restitute those individuals. So when it was created, it was intended to sort of pay out on these cases where the contractors were not in business. They were no longer established. And one of the reasons for the restitution fund was CSLB's administrative process when it revokes these contractors doesn't really provide for restitution. We can order it as a condition of getting your license back, but that's the end of it. If they don't come back to get their license, then there's no restitution. So it was a pot of money designed for those sort of situations. But what occurred was, in the way the language is written, because it's not a disciplinary process, this restitution fund, it's a sort of just payout if we can establish some injury. The statute of limitations that CSLB has to investigate, we can receive and pay out on claims outside of that statute of limitations. So we can receive a claim that a contractor did something wrong and pay the consumer without going through the disciplinary process, but the contractor is still in business. So there was a 1-year window in the statute. And so what we were finding was there are some contractors who are subject to these payouts who dispute the claim. And CSLB can't investigate it because the statute of limitations has passed. So what this would do is just make sure that the disclosure, when a payout is made, goes against a contractor who's been subject to the disciplinary process. Dave, is there anything you want to add to that?
Yeah, just, we had a lot of injured solar customers in 2016. And so when that fund was created, we wanted to be able to provide restitution to those consumer victims. And what we find is that we have contractors that did cause the harm, yet we can't investigate the complaint because we received the complaint more than 4 years from the time the work was performed. Now, our dilemma in those cases is that the contractors believe rightly that they have no obligation to make that consumer financially whole. And it's unfortunate they're not doing that, but when we send it to arbitration, we're in a situation now where a contractor does not have any financial responsibility to pay the fund back or pay the award, but yet would have disclosure on their license for 7 years. And so they will fight that fund payout for that reason. And the fund payout parameters don't require the same level of proof we would need to take an administrative disciplinary action. So it puts all parties to this in a bad spot. And that's why we're hoping that we would have a legislative change where we wouldn't have to put the 7-year disclosure on for those contracts that were entered into in 2016.
And to say it another way, if we had received a complaint, this is for complaints that, the whole thing of restitution is to make people whole where there's not really another remedy. And if CSLB gets a complaint within its 4 years, CSLB will try to remedy. If we get a complaint against the contract within the 4 years, we're not going to send it to the restitution fund. We're going to investigate it to determine if we can have the contractor fix it, possibly order a financial injury to the consumer, that sort of thing. There were cases with the way this law is written, this restitution fund, is we couldn't remedy it for the consumer and the program would pay out and then it would go on the license record as disclosure, but the contractor doesn't really get a hearing or, ability to challenge the disclosure. So disclosure could be seen as kind of penalizing without sort of the penalizing process. So this would change it. So when we're making the payout, we're doing it in the case of contractors that are already revoked. And we're notifying that the payout has occurred, but the administrative part has already happened. The disciplinary part has already happened. The revocation's already occurred. The important thing is the consumer getting the money. And yes, there will be one more disclosure. In addition to the revocation, you've also been subject to a payout from the restitution fund.
Okay.
Does that make sense?
Mike, I could just add
Yeah.
one thing to that. I think you said it very well. If we have jurisdiction to investigate the complaint, the fund won't pay out. So we do get a lot of claims where someone hasn't filed a consumer complaint, they just would like a fund payout, the contractor's still in business, that contractor is required to pay whatever restitution is owed, and if they don't, then what we would do is issue an accusation to suspend or revoke the license. Once we have that accusation of referral, or we believe we have the evidence to support it, then the fund can pay out.
Okay, thank you.
Anything else, Mike?
Nope.
Okay. Once again, the staff has not made a recommendation on this bill, which amounts to watch or staying neutral. As a result, this is an update only, and no action is required of the board unless a board member makes a motion. Anything else on board member comment? Anything from the public? Okay, our next item is on page 169, the PACE Recovery Fund legislative proposal. As your packet states, the Legal Services Group reached out to CSLB and the Department of Financial Protection and Innovation about placing a $60 million restitution fund at CSLB for consumers who were harmed by contractors who sold them property assessed clean energy, or PACE, loans. Staff provided an update to the board about these conversations at the March meeting. The conversations with the sponsors behind this idea continued into May. So this agenda item is here for staff to provide additional updates on this proposal. I'll turn this once again over to Mike as well as David Fote for any updates. Mike and David.
I do not have too much to update beyond what's in the packet. The budget bill does not include that I could locate an appropriation for this fund. We haven't heard from subcommittees. And so I do know, I was able to get a hold of the budget request letter from the sponsors. I just recently was able to get a hold of that. And it's actually a $65 million request to the legislature, but I've not received again. I don't believe that it's in the budget bill is written. It's not in any trailer bills that I've located. So I don't have much to add, but I do believe we have sponsors or the coalition potentially might be here to make a comment. And also we may have some representatives from the PACE industry to make a comment. But that is the information that I have.
Thank you. Staff has not made a recommendation on this item, and as a result, this is an update only, and no action is required of the board unless a board member makes a motion. Any questions from the board? Comments? Anyone from the public? No public comment? All right, that completes the update on 2021-2022 legislation. Let's proceed to the CSLB regulatory matters. Our agenda item 3, regulations. We are now on page 173 of the packet. Before we begin the discussion of this item, I'd like to ask the board chair if she has any comments. Susan?
Yes, excuse me, I do. I'd like to, my comment is that we have board member Alan Guy, who is here with us in the room, represents B General Building Contractors on our board. Alan has asked for guidance regarding whether it is a possible conflict of interest as it relates to the battery energy storage system, or BESS, agenda item, because he is an officer on Anvil Builders and Anvil Power, Inc., that have a C10 classification and is a signatory for the IBEW. After discussion with legal counsel, it was determined that Alan does not have a conflict of interest or need to recuse himself from voting on the BESS agenda item because he has no financial stake in the outcome, and more importantly, has indicated that he can be fair and impartial in the voting process. Back over.
Thank you, Susan. And with that said, the first item of discussion is H2A. Review, discussion, and solicitation of public comment on the expert report regarding a recommendation for possible regulatory rulemaking that would authorize a C46 solar contractor to install battery energy storage systems to an appropriate kilowatt-hour threshold. Before we begin discussion of the expert's report, recommendation for possible regulatory rulemaking, I'd like to make some brief comments about regulatory rulemaking in general. To be very clear, regardless of any discussion of this agenda item or any board vote in the next agenda item, no laws are being made today. No license classification descriptions are being changed today. What the report does provide a recommendation for the board if it elects to authorize CSLB staff to commence the regulatory rulemaking process that is required if the board is going to change the contractor license descriptions in its regulations. The rulemaking process is designed to provide the public with a meaningful opportunity to participate in the adoption of regulations and to ensure the creation of an adequate record for the Office of the Administrative Law. This includes the opportunity for the public to comment on any proposed regulatory text. The rulemaking process has not begun. All the discussions that have occurred at public meetings on this topic over the years has been information for the board to consider as part of the concept stage that occurs prior to the start of any regulatory rulemaking. Even if the board votes in favor of starting the rulemaking process today, the public will still have opportunities to comment on any classification change before it ever becomes law. At this time, I invite the board's regulatory counsel, Danny Rogers, to provide the board a little more information about the regulatory process. Danny?
Good morning, board members. I am Danny Rogers, regulatory counsel for the board. I'm here to provide an overview of the regulatory process and answer any questions that you have. Once the board votes on and approves proposed language, it will be board staff's job to draft regulatory documents, including a notice and initial statement of reasons. This phase can take anywhere from 30 to 90 days, depending upon how expeditiously staff can act to assemble package documents. Once this step is complete, the process begins with the filing of notice with the Office of Administrative Law. This commences the 45-day comment period, during which members of the public can comment on proposed text. The board may hold a public hearing on the proposal if one is requested, and the public can make further comments at this hearing. After the hearing, if held, staff will review any public comments received, prepare proposed responses, and evaluate whether to propose any modified text based on the comments. If the board chooses to modify text, there will be an additional 15-day comment period in which the public can make any additional comments on the modifications. Once the comment period is concluded and the board has approved responses to public comments, the package will be filed with the Office of Administrative Law. That office then has 30 working days to review and approve the regulations. Does anyone have any questions?
Any board members have questions of Danny or the regulatory rulemaking process?
Thank you.
I'm not sure if my comments are in line with what you just said, but I'll ask it and then you can tell me.
Certainly.
I've read several pieces of documentation, and I want to know, is there anyone here from that can speak on the fire codes? There seems to be, from what I am reading, some discrepancies in the capacity of homes when we're talking about the 80 kilowatts. And so I'm reading, like it says, a capacity of 232 kilowatts in some places for small businesses and homes. Then I'm reading that the fire codes say 80 kilowatts is the maximum allowance. Can anyone clarify that for me?
I would defer to Mr. Jimnetsky to comment on whether he might know of any members of the public to comment on that today.
Yeah, I don't want to speculate as to who's in the audience, but I believe we will hear public comment on this very topic.
Okay.
That would probably clarify some of your questions, and if not, we'll find a way to clarify it and provide it.
Okay, thank you.
Any other questions?
Any other board questions or comments? Okay, thank you,
you.
Danny. With that said, I'd like to provide a summary of the board's actions to date on this topic. As the report to be discussed today explains, for several years, CSLB staff has received written and oral testimony on whether and to what extent C46 contractors should install battery energy storage systems from the two primary stakeholders with differing views on the issue. The California Solar and Storage Association, or CALSA, representing the C46 solar contractors, and the National Electrical Contractors Association, International Brotherhood of Electrical Workers Labor Management Cooperation Committee, IBEW-NECA, representing the C10 electrical contractors. In 2019, the CSLB Legislative Committee, as well as the full board, held public meetings to invite stakeholder comments from these groups and other interested parties on the contractor appropriate license classifications to install battery energy storage systems. In December 2019, the board accepted a legislative committee recommendation that an outside consultant be retained to review and make a recommendation regarding the appropriate classifications to install battery energy storage systems. At that time, CSLB entered into contract with UC Berkeley to serve as a consultant. UC Berkeley presented their completed study to the board in July of 2021, concluding that precluding C46 solar contractors from installing battery energy storage systems would have a public safety benefit, minimal adverse economic impacts, would benefit the workforce. In November of 2021, CSLB staff developed a proposal to preclude C46 contractors from installing battery energy storage systems, consistent with the UC Berkeley recommendation, but it was not approved by the board. The board directed staff to develop alternative language that may be acceptable to the electrical and solar stakeholders. The March 2022 board meeting packet describes the efforts of staff between November 2021 and March 2022 in holding multiple meetings with a number of different groups, including the interested stakeholders, an agreement could not be reached on acceptable language. At the March 22 meeting, the board directed staff to retain an outside consultant to provide CSLB an assessment of whether, 1, authorizing a C46 solar contractor to install BESS to a kilowatt-hour threshold within 50 kilowatt-hours or another appropriate range supported by existing codes is prevalent among C46 contractors in the construction business, and 2, and whether such a threshold is consistent with ensuring public safety. The CSLB staff report in consultation with expert consultants has been published, and copies are available in the back of the room, as well as on CSLB's website. The purpose of the expert was to assist CSLB in providing facts and evidence based on their experience and expertise. that would support CSLB amending the C46 solar contractor regulation with a reasonable and defensible kilowatt-hour threshold above which the installation of a battery energy storage system would be no longer authorized in the C46 classification. The report recommends that the board consider amending the C46 solar contractor classification to expressly permit them to install a BESS up to and including 80 kilowatt hours when installed at the same time a solar photovoltaic PV energy system is installed as incidental and supplemental to the solar photovoltaic energy system installation. The report describes the reasons why this threshold will preserve the existing regulatory classification framework, is consistent with public safety and state codes, and is prevalent within the construction business. Registrar Foat, would you like to add anything?
Yes, thank you, Legislative Chair Ruane. CSLB's review of this matter began in 2016, more than 6 years ago. As Board Member Jim Ruane stated, numerous stakeholder meetings have been held and information received from solar and electrical industry representatives. Regrettably, efforts to develop a mutually agreed upon proposal for board consideration have not been successful. As we'll likely hear today, the two industries remain far apart on a solution. The CSLB staff report to be discussed today includes reference to a meeting with the State Fire Marshal and CSLB subject matter experts. I want to clarify that while the report relies on a lot of information from a number of different sources in supporting its findings, for the purposes of the proposed 80 kilowatt hour limitation, the expert consultant is Joe Berrigan. Staff worked with Mr. Berrigan in the development of a proposal that will not compromise public safety and will benefit the public by authorizing the C46 classification to continue to install battery energy storage systems on most residential and light commercial projects when paired with the solar system. CSLB staff is of the opinion that after many years of presenting this topic at public board meetings, discussing facts, evidence, and research reports, the CSLB must commence the regulatory process to include battery energy storage systems within its specialty contractor regulations. Thank you. Back to you, Jim.
Thank you, Dave. Before we invite the board to provide any comments or ask any questions about the report, I'd like to thank staff for their efforts in preparing this report. It presents the information clearly, and the findings appear to be reasonable based on the facts and information provided in the report. I will now ask the board for comments on the report. I will then open it up to public comment on this agenda item. To allow us enough time to conduct our full schedule of business today, I'm limiting public comment to 2 minutes apiece. Finally, for the public, please be sure to sign in. It makes it a lot easier for us on the sign-in sheet outside. This will ensure you are properly identified with your comments in the public minutes of this board meeting. I'd ask now for board comment.
Are you ready to accept a motion that we can talk on, or?
I'd rather receive board comment than public comment, and then we can talk. Anything from the board?
You know, this has been going on for a long time. We've heard both sides on this issue, and for some of the newer board members, we've listened to these comments for years now. We've done our due diligence on it. It's time to act, and I am in support of the recommendation by staff here to begin the rulemaking process. I'll say that up front. So we've heard it all before. We can say it again, but we've heard it all before. So thank you.
Thank you. Any other comments from the board? Yes.
So I've thought long and hard on this, and thinking about, you know, technology and thinking about progress and thinking about, you know, how things evolve. And, you know, there was a time back in the 80s when I had a super hot computer. That was a 286 computer. And, you know, I had a big 8-inch floppy disk, and, you know, I was pretty good. You know, I thought I had the best that the industry could offer. And you know, Slowly and surely, that became obsolete, and every 2 years, it became obsolete. And, you know, as we move away from fossil fuels, I can't help but think about, you know, what the demands on a home were back in the 50s and what they are today, and what will they be in 10 years as we move away from fossil fuels. And are we selling a kilowatt hour that potentially will be significantly lacking in 10 years and won't create, where the intent today is to you know, make sure that it's incidental for residential, in 10 years could be obsolete due to more and more utilities being incorporated into the home that are electrical. And obviously, the improvements in battery and BESS systems and innovations that will create a greater capacity in a smaller space. So those are some of my concerns that we, you know, are not, although today may seem to be an appropriate place to set the bar, but where will we be in 10 years? And does it merit having a situation where we are sunsetting this to allow for an adjustment as the industry improves? So we reset the bar so that we don't disenfranchise small business or workforce people that have invested their careers in this industry. Thank you.
Mr. Chair, can I make a brief comment? So for the purpose of this item, there's no board motion that's necessary. It's for the next item.
Right.
We're just soliciting board comment and then public comment.
That's right, I was going to bring that up. Any other comments from the board? Diana?
Mr. Chair, my question, I believe, is going to be to Michael. As we move into the legislation process, if we go that direction, I know that our Vice Chair, Mary Tiger, played an integral role in some of these meetings, and she's not here for me to hear her comments or recommendations. When we go into that legislative process, does the board have an opportunity to weigh in once it goes that far into that next step?
So the regulatory process will, if there is drafts language that is accepted by the board today to begin the regulatory process, if that draft language changes, it'll be brought back to the board. Or if there's a need to change the language, it'll be brought back to the board to review that before we move forward with any language at all. Does that answer your question?
No, so there's no communication with the legislation committee to produce the draft process with the board? If board members wanted to call and weigh in their thoughts and opinions, suggestions, can they do that?
Once the regulatory process begins, we can reconvene and work with the board as issues arise. But if so just to reconvene the legislative committee during the regulatory process?
Well, no, that's not what I mean. I'll give you a hypothetical.
Sure.
Wait, Board Member Love, what we're asking today is just to begin the rulemaking process. Any proposed text would circle back with the board for final approval, and obviously Mary Teichert's input as well. So this is just the beginning stages. It's a small step, but it's one step forward in this overall regulatory process.
No, that part I understand, it will come back to us.
Yes.
But what I mean is, if it goes to the legislative committee to start, hypothetically, if I wanted to pick up the phone and call Michael in the process of it being drafted and have suggestions or questions or whatever, can I do that?
Yes, so I think that would require a board motion to refer it to the board's legislative committee, if that's the route they want to go as part of the regulatory process. It's not necessary, but if the board is inclined to do so, it may do so.
Okay.
Anything else from board members?
Through the chair. So I have a question on the report itself. That's what this is, board comments on, right? So it's my understanding, like the average kilowatt that's being installed now, I don't know where I read it, but it was like 50 or 20 for like residential, 35-ish for commercial kilowatt hours. Is that actually, that's correct? That's the correct average right now for residential projects, around 20 and 35 for commercial BES systems standalone?
So on page 13 of the report, the data that was used to come up with the two bullets in the middle of that page came from the UC Berkeley report. And this report does describe how these numbers were arrived at. And it is from the UC Berkeley report, and the conclusion, or the data from the UC Berkeley report, was that the average capacity for residential projects was 15.79 kilowatt hours, and for non-residential projects, it was 33.34 kilowatt hours.
Okay, thank you. So with staff recommendation of 80, then it kind of targets that future industry too, is what I'm kind of hearing, of the current average comparable to future, or what this limitation would be for the staff recommendation.
Yeah, I would just state that 80 kilowatt hours is higher than the 15.79 and the 33.34. I don't want to conclude. I don't want to conclude anything. But what I will say is that these numbers are a compilation of 2015 through 2020 from interconnection data throughout the state. So they're grid-tied systems.
Thank you.
Anything else from the board?
Jim?
Yes.
I noticed in the report that there were some unresolved issues, and that the report was completed on June 3rd. Has staff looked at or done any investigation, or has any recommendations with regards to the unresolved issues? Starting on page 15. Specifically, the issue about being able to maintain systems that are installed.
Right. So between 15 and 16, the two unresolved issues are the issue of a C46 contractor taking a contract to install just a battery, and doing so on a system that they may have, a solar system that they may have installed in the past. And that issue, as presented in the report, the recommendation would be that staff and the board would receive public comments on that issue during the public comment period in the regulatory process, and then we would be required to respond to each of those comments. And then for the regulatory, or the issue, the second issue, the economic impact, it would be the same situation. We have to determine the economic impact by law during the regulatory process or present that information, impact to California businesses, and provide an economic analysis during the regulatory process. So while they weren't directly addressed by the report, they were left out to be addressed through the administrative rulemaking process that's required through the Administrative Procedure Act.
Any other questions or comments from the board? All right, thank you. As we discussed earlier, we are limiting public comment to 2 minutes. At this time, I will now invite public comment. Please form a line at the side of the room, and thank you very much. Thank you. Please state your name and your association. Thank you. No, push the button.
Great, thank you. Good afternoon, Heather Minner. I'm legal counsel for CALSA. Before the board begins the rulemaking process, it should make sure it has a rational rule that does not unduly burden the solar industry and its customers. This is not that. The 80 kilowatt hour threshold will be incredibly harmful to the solar industry. I want you to consider that the most common battery installed for small commercial projects is the Tesla Power Pack, and that has a 232 kilowatt hour threshold. So you would be cutting off solar contractors from all of that work. We've also reviewed the interconnection data and found that there are, for grid-tied residential projects, there are 760 already that have batteries exceeding the 80 kilowatt hour threshold. Batteries exceeding that threshold are also common in off-grid residential projects. This impact will not just affect solar contractors who have a C46 license only, but will also affect contractors with a dual license, a C10 and a C46, because it would require those contractors to use certified electricians for their battery work, and there are not enough certified electricians available for those contractors to come into the solar industry and perform these projects. Also, not only is this going to be incredibly harmful to the industry, there's no justification for it. There have been no incidences of problems with battery installations by solar contractors. None have been brought to the board's attention in the 6 years since we started this process. The number 80 kilowatt hours is pulled from the fire code and the residential code table, and the state fire marshal recently clarified that 280 is the appropriate aggregate number from that table. The report recognizes there's a problem with this, and so tries to justify it with this new concern that brought up the first time with solar contractors
That's
tying
2 minutes.
to three-phase. They do that every day when they install solar panels and batteries. Thank you.
Thank you. Next, please. You state your name and your association. Thank you.
Good morning, board members. My name is Mike Mendoza. I'm a state certified electrician, and my comments today are about C46 only contractors installing energy storage when paired with PV solar. As a state certified electrician, this is an issue of safety, of equity, and precedent. This is not an issue of union or non-union. The vast majority of C10 electrical contractors are non-union shops, but all C10 electrical contractors are required to use certified electricians to perform electrical work. This is no different than requiring a solar contractor to hold a roofing contractor license if they want to replace a customer's roof before installing solar. And after listening to the SWIFT report earlier this morning, I'd say it's kind of important. Thank you.
Thank you. Next.
Good morning, members of the board. My name is Joel Pickett. I'm a California State certified electrician. My comments today are about the C46 only contractors installing energy storage when paired with PV solar. This is also not about trying to take away jobs from C46 solar contractors. Most C46 solar contractors already have a C10 license employing state certified electricians or other licenses that allow them to install energy storage systems. This matter is based on CALSSA's making outlandish and misleading claims in order to protect their 300 contractors that won't be able to expand into energy storage work without the proper licensing and without investing in additional safety training for their workers. Thank you very much.
Thank you. Next, please.
Hi, my name is Megan Stimler. I've been here before. I'm representing my family's C46 solar company, Solar Hut in El Dorado County. We've been installing batteries since 2008. We're kind of the old school battery people. We know what we're doing. We have contacted many C10 contractors in our area to see if they would like to help us with the installation of batteries. Those have all gone unanswered. They don't want to do it. They're making their money on new builds, generators, all those types of electrical fields. We are the experts. We're trained, we're certified. We know what we're doing. We are the solar companies. You're gonna limit the expert knowledge on battery installations. You're going to remove the ability for us to retrofit our customers, to add batteries. We are experienced. The demand for adding batteries increases every day. I get many phone calls every day from my customers asking, when can I get a battery? How do I add a battery? The demand is coming. And between California's demand for clean renewable energy, public safety shutoffs, the changes of time of use rates, increase of electrical car demands, batteries are the future of California. Please don't limit our ability to move forward in advancing technologies. Thank you.
Thank you. Next, please.
Good morning, board members. My name is Rene Cruz Martinez. I am a utility employee, and my comments today are about the C46 only contractors installing energy storage when paired with PV solar. I respectfully disagree that there is any compelling justification to expand the scope of the C46 contractor license regulation to further overlap the scope of the C10 electrical contractor's license. However, if the board were to amend the C46 license to expressly allow some installation of battery energy storage system when paired with solar PV, a limit based on the size of the battery energy storage system would make more sense from a technical, safety, and economic perspective. Thank you.
Thank you. Next, please.
Good morning. My name is Charlotte Stevens. I'm a utility employee. And my comments today are about this C46 only contractors installing energy storage when paired with PV solar. As a utility employee, this is an issue of safety, of equity, and precedence. This is not about union jobs. The vast majority of C10 electrical contractors are not union shops, but all C10 electrical contractors are required to use certified electricians to perform electrical work. This is no different than requiring a solar contractor to hold a roofing contractor's license if they want to replace a customer's roof before installing solar. Thank you.
Thank you. Next, please.
Good afternoon, board members. My name is Natalie Higley, and I work in the electrical industry. Enforcing traditional contractor license classification requirements would have no meaningful impact on solar and energy storage installation other than to improve safety and quality. The 300 or so C46 contractors who don't hold an additional license that would allow them to install energy storage systems are responsible for just 6% of solar installations in the state and just 3% of energy storage systems. The staff proposed amendment allowing C46 contractors to install battery energy storage systems up to 80 kilowatt hours in size is going to turbocharge the percentage of battery energy storage systems that are performed by contractors who only hold a C46 license and do not use certified electricians. I don't think that's fair to the rest of the industry, and I support clarifying this through a regulatory rules-making process, and I encourage staff to consider lowering the threshold size.